Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law in San Antonio, Texas. Today's guest is Alexandra Lahav. She's a nationally recognized expert on the civil justice system, complex litigation, and tort law, and is a professor at Cornell University School of Law. Welcome, Professor.
Thank you so much. Thanks for having me.
Well, I'm delighted to have you, and I'd love for you to tell us a little bit about how you arrived at Cornell and what prompted a relatively recent move to Cornell.
So for many years, I taught at the University of Connecticut, which is a great place, and I got the opportunity to move here. Cornell has a couple of really fabulous civil procedure scholars. And so for me, the opportunity to engage with them was a huge draw. Just the opportunity to get to know a different set of students, which is not to say that my students at UConn weren't fantastic, because they were fantastic. So it's been fun to be part of a new community. I think you might share this, that one of the things about being a professor is we kind of get our job and then we stay in it for a long time. I think sometimes having like a fresh new start is good. So I was very happy to move, even though I was sad to leave my friends in Connecticut.
Understandable. How long were you at the University of Connecticut?
I was there a long time. So I was there for like 16 years.
Oh, yeah, that is a long time.
Yeah. So that's what I mean. Like, it's good to try something new. So connected, I know we're going to talk a little bit about the casebook. Before I went to the University of Connecticut, I was a civil rights lawyer in New York City. And so it was that experience that spurred my interest in procedure. And so when I went into academia, that's what I specialized in. But I've been an East Coaster the whole time.
Got it. So you were referring to the book, and Aspen has just released the 7th edition of Civil Procedure, Doctrine, Practice, and Context. You have 2 co-authors, Mark Broden and Thomas Main, and I'd love for you to tell us a little bit about your history getting involved in the text and what the theory of the book is.
Yeah, so this book was first created, or the leader, I think it's fair to say, was Steve Subrin. And Stephen Subrin is now emeritus, but was for many, many years a professor at Northeastern Law School, which happens to be where my co-author Tom Main went to law school. So that's really nice. And Steve was one of the really great pro scholars of his generation. He wrote some articles that everybody in the field read and relied on. And he had this unique approach to teaching that he wanted to bring into a casebook. And a fun fact is that when I was a law student, Martha Minow, the original co-author with Steve, was using the materials that would become this casebook to teach us. So she had what I'm going to say is, like, in scare quotes, a proper casebook. And then she had this like giant photocopy thing that we all got. That was the book she was writing with Steve. And Steve, I think, also brought on Martha, and I think he brought on Mark Broden, who's been on the book the entire time. And later, as Steve and Martha sort of slightly moved on to other things, they gave the book to Tom and me. And so I came on, I think, in the 5th edition of the book, but I had been using it and studying, and I had studied from it originally. So I feel very immersed in this particular book because it's really been my whole history as a Civ Pro student and a scholar has been through the lens of this book. And you asked what the theory of the book is, and that's why I was saying about my previous experience as a civil rights litigator. What made, I think, me a really good fit as an author of the book is that Steve's vision was always to have the book see procedure through the lens of civil rights litigation. He was a civil rights litigator, I think, and a civil rights scholar, mostly in employment discrimination. Mark Broden is a well-known employment discrimination scholar, in addition to a lot of other things. And so there was this idea that and Martha Minow has obviously been very involved in civil rights issues. She's had a very storied career. And so I think that's why it was a good fit. So the theory of the book is it looks at procedure. Not every case is a civil rights case, but through a civil rights lens. And it has kind of a theme, which is to show the students the practical effects of procedural rules. So how is procedure, it's well known among academics to say procedure is power, but how does that operate? How is procedure powerful? How is procedure in tension with justice? When we say, a technical rule of procedure prevented us from getting to the merits, right? You're saying something about the power of this thing that's technical, which seems bad. Usually we don't say, it was a technical rule. That's fantastic, right?
Well, maybe you all do. Maybe some throw scholars do, but I never say that. No.
No, we sure don't. If we're saying something is technical or picayune or whatever, we're all sort of denigrating it. Now, people will say, well, that's not a technical rule. That's an important rule. But people outside our field, I think, might say, okay, buddy, like, I know what that is, and it's not that important. But I think it does form this backstop to how people enforce right. And that's what we are trying to show in the book is how does that happen? What does it mean for American life? How do these procedural cases that we read fit in to kind of the broader history of American life, society, and law? And so that's why Steve called it doctrine, practice, and context, because the idea was yes, all the doctrine is there. Everything you want to know about Civ Pro doctrine, from filing a complaint to a trial, subject matter jurisdiction, Erie, it's all in there. Every topic anybody would want to teach, even some topics people rarely teach, like can you add an anonymous plaintiff to your case, for example. All of those things are in the book. But the book also has a lot of practice exercises that try to put the student in the position of a lawyer, really thinking through the issues. And then it has a fair bit of context of the cases. When was this decided? Why did it come out this way? Given the society in which it was being decided, how has the law evolved over time and changed as society has changed? So that's sort of thematic in the book. It doesn't pretend that law is static or always the same. It shows that how dynamic it is. And I find that students find that to be actually quite hopeful. I mean, they're not always agreeing with changes in the law. We've seen a lot of changes, especially at the Supreme Court level in recent years. But I think students find it pretty inspiring to know that law changes and they can be a part of that. So when they're part of the legal profession, they're going to be, as they litigate cases or if they become authors of rules, if they become judges, they're going to be making the law. And so that's what I love about the book is the way it also, through that history, it illuminates some of the policy decisions and some of the ways in which in the past we were worried about X, but today we're more worried about Y. What does that mean for these rules? And I find that students, despite the material being, I think, sometimes extremely difficult, are really engaged because they can see where everything fits in. And I think the context part of the book, it can't be underestimated how powerful that is for students and helpful it is for them. You don't want too much because then they'll say, why are you giving me all this stuff? But you want to have a nice balance so that they can see what the significance is of what they're learning.
Completely agree. I'm sure that they appreciate the context very much, especially the historical context. And I'm glad that it is inspiring some of them to understand that they too can change the law. It's nice to have that framework to show them the evolution of the law. So the goal for the authors is to present all the doctrine that's needed, give practice exercises, and then have this context. What else differentiates this book from other civil procedure case books on the market?
So I think a couple things. One is, over these many years, there has been a trend towards somewhat thinner books. So a little bit easier, a little bit more accessible, shorter case excerpts. We haven't really moved in that direction. So we give pretty fulsome cases, not insanely so, but the book remains pretty long. I think that's a real plus that I hope people will take a look at the book and really think through, because the students can handle it. The students are better than a lot of people give them credit for. And I taught at a lot of different law schools. I was a visitor at Harvard. I teach at Cornell now. And for many, many years, I taught at UConn. I've taught a wide range of students with a wide range of abilities, all out of this book. And I find that it really works to give them a lot. I don't think you can assign too much reading. You have to be judicious, but it's nice for them to see a case where it's not just a squib, where they're getting sort of the full sense of the case. I think that's a nice thing about the book that I worry is a little underappreciated. The other thing the book has that's fabulous is it has this case study that Steve Subrin created. And he created it years ago. But this case study is fantastic for teaching doctrine. And he created these wonderful exercises for using these case study materials so they're in the back of the book. It's a case about a man who jacked up his truck or his Jeep using these giant tires, like the kind you see in like the monster truck rallies.
Yeah, I've seen them. I see some out here just on the road.
Okay, yeah. And so he did it. This is a true story. He jacked up his Jeep with these giant tires, but in order to do that, he needed to use something to stabilize it. And he had seen in some way, I don't really know how, because this case occurred before you could just watch YouTube videos about how to jack up your truck or whatever. But it was the functional equivalent of that. And he raised it up using hockey puck. And it turns out that isn't the best idea. Like, he bought a kit, and then to help make the difference between the kit and the tire, he used hockey pucks. And he was in a tragic accident where he took a turn too fast and he killed the passenger of his car, who was a good friend of his. And so the example is a lawsuit between the decedent's wife and the companies that sold him this lift kit to put the tires on the car, as well as the gas station that inspected the car, and the city that had stopped the guy who owned the car before, but didn't give him as much of a citation as maybe they could have. And so there's a bunch of defendants, and you talk about, so it goes from an evaluation of the claim, and it's a relatively simple tort claim, so it's easy to get your head around as a 1L, but it's also got an interesting set of facts. There's a deposition, an excerpt from a real deposition in the case. He includes the relevant law, so the students can read some short excerpts of the relevant law and use that to argue their motion to dismiss, to argue their motion for summary judgment. And every year I do an exercise. Actually, every year up until this year, I wasn't able to do it this year for reasons that are a little boring. But every year I've done it, these many years. And the students just love it. They argue the case so well. They draw on all the materials, and they're so responsive. They really prepare. That's the assignment for a class. They don't do any reading. They just prepare their summary judgment motion. And it allows them to internalize the burden shifting and the type of motion that summary judgment is. It's kind of hard to teach, but in this practice exercise, the students really internalize it. And you see it actually on the exams. They quite understand what is going on because I think they do this exercise. And there's a bunch of other ones that come out of this case file. So it gives an opportunity for the students to really see a case. We used to have a civil rights case as well, so we had two. But we found that users weren't using the civil rights case, and so we cut that out just to save some paper for people. Any listeners who are interested, I'm just offering this up. I'm easy to find online, but I give the students a civil rights case every year, a different one, where they can see the papers, so they can see, what does a complaint look like? Or an interesting case. What does a complaint look like? What did the motion for summary judgment look like? Sometimes I'll have a little bit of discovery disputes in a real case that students can read, and then we do a little bit of class discussion around that, just so I don't want the first time they see a full complaint to be in a clinic. I want them to be able to have seen it right at the beginning of class. And obviously they have it in this case file, but sometimes I'll give them these things from very sophisticated lawyers. So this year I don't know if you're familiar with this lawsuit, but the Dominion Voting Company, voting machines, they sued Fox News. They brought a defamation suit that made really big news. All of the papers were available online. So I downloaded them and I picked a few that I thought students would really enjoy. And it was great. Students were able to ask, why did they make this strategic choice? Why are they in state court and not in federal court? And why are they in Delaware and not in New York? And so we were able to have these discussions in class that were really great. So I really recommend in general trying to use some real materials. But what's nice about the ones in the book is that it's all set up so that when you do a practice exercise, you know where all the pieces of the material are that students should be drawing on, and you can kind of prompt them. You can say, does the deposition tell you anything about this? And they can go into the deposition and pull out an argument. And that's been really beneficial for them to see how the stuff you did previously on the motion to dismiss and in discovery is going to impact now, for example, your summary judgment motion or the remedy that you are seeking. And so I think that's a really extra special, useful part of the book.
So when you mention the case study, do you teach civil procedure as a fall first year course?
So for many years, I taught it as a fall first year 4-credit course. Mm-hmm. At Cornell, like a minority of schools, we actually have a full year civil procedure course, and we have 6 credits, which is just an incredible luxury. So I'm really able to get into things that are in our book, but I would never be able to get into in a 4-credit class. So that's been just a really cool part of my new job, is that I can go into some things involving multi-district litigation, which is a hot topic. I have enough time to bring in maybe a guest speaker to talk about, some fancy lawyer to talk about their litigation experience. So that's, I have a lot of bandwidth. But for many years, I taught the 4-credit, which I think is the minimum number of credit available for Civ Pro teachers. So I know it from all angles. I know when you're trying to really cover a lot in a short period of time, and when you have the luxury of 3 units in the fall and 3 in the spring, you could get a lot done, and it's great.
I was just curious. I also took, back in the day, I took Civ Pro, and it was a full year course like that. But I was curious because I was thinking if they had that case study and they were arguing those positions in the fall of their first year, how enthusiastic they would be, because they haven't gotten to that kind of moot court persuasive writing and oral argument that they usually get into their spring semester of their first year. So that's got to be exciting to them. You have seen this book from Martha and Steve's idea and copious notes and photocopies and all of that to the 7th edition, having contributed to the 5th, 6th, and 7th. How has the book changed over time?
So I would say the bones remain basically the same. We continuously update the cases. We add background and we update the background. So in earlier editions, for example, like I teach the due process, or I write, the due process chapter. That's one of the chapters that I'm in charge of. And I used to have a bigger focus on due process for welfare recipients, so Goldberg and Matthews, and then a short essay on welfare reform and stuff like that. And we still have we have a little bit of that in. I've shortened it a little bit, but now I've expanded the discussion of prejudgment remedies. And there's a case from the late 60s, early 70s called Fuentes. It's a Raplevin case. So it's a case about a person who had bought something in a payment plan, and she missed the last payment of $200, and they came and tried to take her stove. And the question in the case is she entitled to a hearing before they come and take her stuff? Now, that is very relevant. Even though it's an old case, it's very relevant to the crisis in the state courts today involving debt collection. So I've added narrative material on debt collection in the state courts, on preliminary remedies. We used to have some stuff about more practice exercises about things involving like prejudgment remedies against organizations that are accused of being terrorist organizations. That was really hot in the mid-2000s. Now we have other types of examples. Like I just included in the newest edition an amazing, I think, problem involving, I gleaned this from a study that academic named Jim Greiner at Harvard did with co-authors of the Philadelphia divorce system. And it turns out that the procedures for getting a divorce in Philadelphia are so complicated that only, I think, 9% of people who are unrepresented are able to get a divorce in Philadelphia. Even if it's totally uncontested, they got together, they know they want a divorce. It's just so complicated. And so I have a due process problem about, can that level of complexity violate due process? And the students need to analyze it using the Matthews test. We've changed the focus of some of the things to really be bringing up hot issues of the moment. But what's so fascinating is the way in which the issues that are so hot right now, if you look for historical analogs, you can find historical analogs from the 1860s when people were engaged in massive debt collection through the courts. I just read a book about this, to the 1970s when this was a major issue, and today. So there is a continuity of the type of concerns that we have in the procedure system. So we can have that continuity while still bringing up very prescient topics where the students feel like, oh, that's relevant. Like I'm reading newspaper articles about eviction. I'm reading newspaper articles about debt collection, and it's in my casebook. And I think that's really nice for students to feel like, oh, this is relevant to something that's in the news, that when I go home and I talk to my family about what I'm learning in law school, I can tell them things that they're going to feel to them like, oh, you're learning something that's sort of real life. That would be the thing that I think is most exciting about the changes we've made, is that we're able to keep that continuity while adding kind of most up-to-date problems and cases.
Yeah, and that continuity includes that historical perspective and context is, I'm sure, very interesting to the students. So Civil Procedure, Doctrine, Practice, and Context, the 7th edition with Broden and Main, and one of the more popular books in the field of civil procedure. So that 7th edition just came out. Thank you for sharing that about the Aspen Publishing book. I did want to ask you before we get to our last question about your award-winning book In Praise of Litigation that you wrote and was published through Oxford in 2017. What is the general premise of the book?
So that book actually came out a lot of my teaching. It was ideas that I've been thinking about a lot as I was talking to my students about what is the system good for that you're learning about. And so the book argues that litigation is part of our democratic system. It promotes democratic values. And I talk about 4 values: enforcing the law, treating people equally. So we have at least a principle, the question of whether we live up to it, I talk about in the book, but that litigants should be treated with equal concern and respect, that people should be able to participate. Litigation is a way sometimes for people who otherwise don't have an opportunity to say to vote. They can still bring a lawsuit to say, you should treat me in this way. I'm thinking particularly of prisoners who are denied the right to vote because they're convicted of a felony, non-citizens. So that's a way of being heard. It also promotes transparency. So there's been a lot of cases where there was information that was really important for the public good that was not available until somebody sued and said, I want to find out what happened. And it's through litigation that we learn what happened. So in the book, I write about all those phenomena, and I say, look, this can promote democratic values. Since the book came out, there's been some changes in the way litigation has been operationalized, or maybe some people might say weaponized. So I think the debate is much more fraught than it was in 2017 about what happens when we use litigation, or when people want to use litigation and create private rights of action. You're familiar with this from Texas, something like SB 8. Is that anti-democratic because it's allowing anybody to bring a suit against a person? Does that chill behavior that it shouldn't chill? How do we judge when litigation is good and litigation is bad? I think is an issue that's very much on everybody's mind. I don't have an answer for that. I just want to flag it as an important issue. In the book, I don't have an answer for that. And I still don't have one, except to say that a lot of it is about your values, that you might feel okay with promoting litigation when it's going to be used to promote values you think are just. And you're going to be pretty mad about it when it's being used to promote values you think are unjust. But litigation doesn't help you solve the problem of what is just and unjust. So we can have that conversation in a courtroom in some ways, within the constraint of what the law allows, but it's no replacement for obviously a democratic kind of dialogue. So I'm a deliberative Democrat. I think we should have more dialogue about these issues. But as I'm sure everybody who's listening knows, it's becoming more and more difficult in American society. And I still think the courts offer us an opportunity for people to speak on equal footing and make their case, as long as they are being treated equally by the court, to try to make their case. And sometimes they use it as a way to make a case. They bring a lawsuit, but they're really trying to make a case to the country as a whole through that lawsuit. And in the book, I say, and I still pretty much believe, that that's a feature of our democracy. It's not a bug.
Excellent analysis. And yes, it's increasingly difficult to have those conversations. An interesting point that at least you can still have them in the court system. But that's if you can access the system, right? That's another layer to that whole discussion.
So I was just going to say, that's one thing I'm working on now is some empirical work on what are people able to do in the court system. And so there's a lot, and I would just say in general, there's a ton of really interesting empirical work that procedure scholars are doing, trying to figure out what's stopping people from being able to access the system. And it's a very interesting area that I think we need to think more about.
Well, I'm glad you're looking into that. Before the final question, I made a note when you asked it. Can you add an anonymous plaintiff?
Yes, you can. You can, but there are constraints. So you can sue as a Jane Doe or a John Doe. but there are constraints on when you can do that. So you need to have some good cause. I won't go into like the specific rules, and you can also sue defendants that you don't yet know their names, but you can there's some ways in which you can get into trouble when you do that. So we talk about that in my class of when somebody names an anonymous corrections officer, and then after the statute of limitations has passed, they figure out the person's name and they relate that back. In most circuits, you cannot relate that back. And so you end up losing that claim. So it's a tricky business to sue somebody not under their own name. That's the bottom line.
Okay. Important lesson. I'm glad you said that. So can you please share with us what your predictions are for the future of legal education in the coming decade?
Yeah, I think we're going to continue to see more people interested in practical learning in the law school. So that's been a big movement since the 70s. So it's not like new, but I think it continues to be really important. I'll confess I'm a little worried about attention to doctrine. I think we need to balance experience with learning doctrine and being really rigorous about that. I think students are thirsty for that. Another big challenge that I think it looks like it's going to change legal education is probably the advent of AI that it can't do very good legal research so far from my experience.
A lot of hallucinations out there.
Yeah, I would not advise my students to be using that, but it can write for you. If you know what you want it to say, it can write it up. And that I think will change the way people do law. But I'm not sure how. I think it's still up in the air. And, I'm thinking I wasn't there for it, but there was a moment where people transitioned from most of the stuff we did being in paper and in books to computers. And there have been changes, like we all do our own word processing now. We don't give it to somebody else to do. But in many ways, things are the same. We still print out cases to read them, at least if we're trying to be careful. And I will say, I think one of our biggest challenges is making sure that our students, who I think are increasingly drawn to video type information sources, retain the ability to read really carefully, read legal materials really carefully, because I think a lot of times winning the case is based on a careful reading and analysis. I really want my students to be able to do that, which is not to say they can't enjoy and benefit from videos and outside materials, but at the end of the day, the law is the statute or the thing that's written. So I would say that's a big challenge. I don't see that changing, but I feel like the way we access it is probably going to change.
And really excellent point, and one that I haven't heard before.
Well, I'm glad to offer something new.
Yes, absolutely. I mean, of course, AI and more move to online or even video, but that we may be losing the skill then to read carefully and do that analytic work we need to do as lawyers. So
yeah, or at least we need to, keep working on it. We can never stop working on it, because that's at the end of the day, that's what law is. And, we want to pay attention to that because we're representing people who want to prevail in their lawsuits or in whatever they're trying to achieve.
Well, thank you so much for joining me today to talk about Civil Procedure, Doctrine, Practice, and Context, the 7th edition by Aspen Publishing. Also sharing a little bit about your approach to teaching and the goal of the authors and the theory of this book and the new edition. Good luck with the rest of the semester, and thanks again.
Thank you so much. Just a pleasure to talk to you.
Thank you, Professor Alexandra Lahav. If you enjoyed this and want to listen to other authors and thought leaders in the Academy, you can access additional episodes on Aspen Leading Edge Podcast's webpage on the Aspen Publishing website or where you get your favorite podcasts. Thank you so much.